Good day, Crime Talk aficionados. This is Crime Talk. My name is Scott Reisch. Thanks for watching. Before we get to the docket, first, if you haven't done so already, please subscribe. Hit that little like button over there in the corner so that you receive notifications of when we go live or put up new content. And as always, leave me a comment below about what your thoughts are about what we talk about today. Now, first on the docket, a few more thoughts about the court's decision last Friday in the Lori Vallow Chad Daybell matter. For those who don't already know, there was a hearing spread out over the course of 2 days last week based upon the allegations made by Lori Vallow's attorney, Mark Means, and it was joined by Chad Daybell's attorney, Mr. John Pryor. So we had a hearing based upon these allegations that come from an interview where during the introductory conversation between the prosecutor, Mr. Mark Wood, and a witness who happens to be Lori Vallow's sister is recorded by Miss Shiflett's attorney. Well, needless to say, this tape gets turned over to Mark Means and he blows it up. And let me just say, we've talked about this. We've actually put the transcript up. It was emailed to me before it was even available basically on the internet. We put it up at scottreisch.com. You can go check that out. Read it for yourself. You can also listen to the court hearing that we put out there live, and there's nothing on there that was misconduct on the part of Mr. Wood. I said this from day one. I don't get it. But needless to say, the court set it for a hearing. I believe the court made the correct decision at the end of the hearing. A little surprised at how long it took, and it certainly seemed like he allowed the defense, who had the burden of this particular motion, to show that some misconduct had taken place and that the due process rights of both Lori Vallow and Chad Daybell were somehow harmed. Needless to say, the court said, you haven't met your burden. Oh, and by the way, if there was something that was inappropriate, unethical, the appropriate venue for that would be through the Idaho attorney regulations. And guess what? There was somebody there listening to those proceedings. And why would attorney regulation be that involved in a hearing where the judge is taking evidence? Well, more than likely, those allegations had been made to the state bar, and so they figured, let's just have one big hearing and resolve it once and for all. Needless to say, it didn't go like the defense planned. First, they didn't call Miss Shiflett to say that she was intimidated in any way. She wasn't called to say that she changed her story based upon the conversation that she had with Mr. Wood. That is what would have been necessary for that motion to prevail. Additionally, the two experts that were called by the defense simply didn't give the defense what they needed. First, you had the psychologist who was up there saying, oh, these words could be used to suggest something. Okay, would be, could be, it doesn't matter. Until you have a witness come in and say, yes, this is actually what happened, it's all speculation. Then you had the law professor who's in there saying, oh, this was really bad. You should never do anything like this. I don't know where this guy's practiced law or if he just teaches class in the law school, but he has no concept of reality whatsoever. And like I said, you can take a look at that transcript. Nothing inappropriate, with maybe the minor exception. You shouldn't really say that somebody is a bad attorney to somebody that's involved in the case. Is that going to sway their opinion in some way? I doubt it. But these are real conversations that attorneys have with victims. As you may recall, Miss Shiflett is the aunt to JJ and Ty Lee. That's right, the two deceased children. So I think that they need to have the right to know what's going on with their case as it relates to a family member. Additionally, what did Mr. Wood say that was so offensive? He said that when Mr. Means is not out there calling him a liar, which is true, he's been saying that from all along, that he's never done a felony case, and maybe someone will be competent in the sense of someone who is a competent criminal defense attorney would get on the case. All true statements of fact for sure. Now, next, I was a little disappointed. Now, I have said I don't have a whole lot of professional respect for Mr. Means. As you may recall, he made a big deal early on where he said that his calls with his client, Lori Vallow, were somehow recorded at the jail. And if one or two was recorded by accident and they had investigation, they called officers to the stand that testified and said one or two were in fact recorded. But once they determined that there was an attorney-client call, guess what? They deleted it. The remedy was not a reduced bond. Okay? Just like Mr. Means saying, the district attorney was mean to me. The correct remedy is cross-examination at trial to make the district attorney look like a bad guy and he doesn't play fair, not a dismissal of the charges. Simply not good. And that's exactly what Mr. Means did in this situation as well, asking for the wrong remedy on something that doesn't amount to a hill of beans in the big picture. I guess, though, what I'm really disappointed in is I really liked Mr. Pryor. I thought he did a really good job at the preliminary hearing for Chad Daybell. He really laid things out. And, the case wasn't going to go away after that hearing. The standard of proof is very low. It's not proof beyond a reasonable doubt. But he started laying the groundwork. And so I thought that Mr. Pryor was, for lack of a better term, the adult in the room for the defense. But he not only joined, but then he kind of got a little rambunctious in the hearing. And I think he knows it wasn't the right thing to do. Maybe his emotions got the best of him. The next thing is, what a waste of money. Now, let's just say reasonably, I don't know what Mr. Means charges per hour, but let's say he's charging $300 per hour. We were in court 2 days last week, but that's it. All right. But you have to consider when you start talking about attorney time to get the information, review it, investigate it, analyze it, do some research, talk with experts, retain experts. Let's say those experts each cost $5,000 to get a retainer for them to review the material and write an opinion and then show up in court. Let's say $5,000, being very conservative right there. But the attorneys probably had 80 hours into this little endeavor. So guess what? 80 hours, $300 an hour. Guess what? $24,000 in billable hours. Add on experts, another $10,000, $34,000 of time and effort that went into that. Wouldn't you like to have been a fly on the wall when Mark Means had to contact Lori Vallow and explain, our limited resources and funds were used, say $24,000, $34,000. Maybe it was divided up. Maybe it's a flat fee and it really doesn't matter. But let's just assume it's by the hour. Spent that kind of time and money and got nothing out of it. But what did they get out of it? I think they lost some credibility with the judge. The judge, what did he finally say? Judge Boyce at the end. We need to have civility. He expects that in the courtroom. He expects that out of the courtroom, just like any judge will tell you. And that's expected of all attorneys. So I think they lost a few points with the judge. And when it comes to being an attorney, you have one thing, and that is your reputation. All right? And if you fly off the handle and everything is a travesty of a mockery of a sham, and this is outrageous, and you're offended at everything, guess what? The courts don't listen to you because you're the guy that always goes off the handle. And when you really do have an issue, guess what? They're not going to look at it as closely because you're the guy that always goes off the handle and is always outraged and is always upset with everything and what every side and what everything on the other side does is completely criminal. You lose credibility. Now, what did they get for sure? They now have a pissed off district attorney. And why should the district attorney be pissed off? It's one thing to say, you're being mean to my client. Oh, why aren't you giving my client a better deal? You can't prove your case. Well, the district attorney believes that he can prove the case. And if he doesn't think he could, he has an ethical obligation to dismiss the case. He clearly thinks that he can. But now when you accuse the district attorney prosecuting your case, the same district attorney you may have to go hat in hand with and ask for a plea bargain in the case. He may. Now, I think Mr. Woods will be professional about it and do the right thing. But guess what? He's going to make those defense attorneys stew. And bottom line, he pissed off the DAs. Can you imagine if someone went around calling you a liar and unethical all day when basically your job is to be a truth teller, to bring truth to the table? That's right. You would be pissed. I'm telling you, your reputation is what gets you places. As a defense attorney, It's what gets you maybe a little better deal with the district attorney that you've dealt with before, that maybe you've gone to trial and you've won, or even if you lost, you were a straight shooter and you played fair. They're going to remember that. And if you don't file motions every time something goes up, when you really do file something, they'll take a look at it. I've had district attorneys, I've had judges refer me clients and family members. Your reputation and competency matters. Next on the docket, former police officer Derek Chauvin was originally going to stand trial with his fellow officers who were all charged in relation to the death of George Floyd. Well, the judge has changed his mind. The judge has said, due to ongoing coronavirus pandemic issues, the courtroom in which they had planned to have the trial simply is not big enough to comply with CDC as well as state guidelines to have the attorney, counsel, prosecutors, judges, and jurors spread far enough apart. Therefore, the judge has said, Mr. Chauvin, you get to go first and you get to go alone. Needless to say, his co-defendants who had asked for their cases not to be joined are completely happy with the severance the court has now granted them, not even by asking for it. That's a pretty nice gift for those co-defendants. I assure you, the co-defendants, though, are still going to be pointing all of their fingers at Derek Chauvin, and what is the beautiful thing for the co-defendants is he won't be there. I'm sure Mr. Chauvin wanted everyone to be together for trial, so maybe he could hide a little bit and maybe spread the blame around just a little bit. Needless to say, now Mr. Chauvin will be there on his own. Now, the prosecutor wanted all of these cases tried together. Certainly, they're not going to be happy, and we'll wait and see if they're going to file any kind of objection or ask that we delay the trial so that we can have everybody in there, maybe when these vaccinations get around to more people and the COVID-19 virus will not be such an issue. Needless to say, Mr. Chauvin's trial could go as early as March, and the co-defendants now have a trial date of August 23rd, 2021. We will continue to watch that case. The court has already said that they are going to allow it to be televised, basically via YouTube, and we will bring it to you live. If there's one case that should be televised, it should be that particular case so that everybody can see what evidence exists and what doesn't exist, and so people can make up their own mind about the facts of that particular case. Next on the docket, Ghislaine Maxwell wants to go home. As you may recall, Ghislaine Maxwell put together a bail package for the court to consider. It totaled $28.5 million. But the problem of most of that was with a personal recognizance bond and only a few $1,000,000 of maybe your husband, not really your husband, putting up a few bucks. And then she was going to hire a private security force to protect her, kind of like the fox protecting the hen house, so to speak. Needless to say, the court denied that motion. Well, guess what? Ghislaine Maxwell is going to appeal. And for an appeal to be successful, there has to be some legal error that was made that resulted basically in an unfair hearing, or that the court's decision was arbitrary and capricious. Basically, they just made it up. As long as it was founded in the law and supported by the facts, guess what? The appeal is going to be denied, and Ghislaine Maxwell is going to remain in custody. Judge Nathan, the trial court judge, found and concluded that none of the new information that the defendant presented in support of her application has a material bearing on the court's determination that she poses a flight risk. The court stated further, for substantially the same reasons as the court determined that detention was warranted at the initial bail hearing, the court again concludes that no conditions of release can reasonably assure the defendant's appearance at future proceedings. Right? We have talked about this before. The fundamental principle that relates to the law of bail is that the judge has a duty to protect the community and make sure that the bail is high enough to make sure that the defendant will not flee, i.e., Is there enough holding them there, i.e. if you lose, for example, if you leave the country, they're going to take all your property or the property of your friends that put up the collateral. The court said here there is no combination or condition that the court felt comfortable with releasing Miss Maxwell. I anticipate that the appellate courts will deny her appeal promptly. Now, for those of you who have been waiting, yes, Miss Ghislaine Maxwell has been in custody now 196 days, which comes out to 6 months and 12 days. And for those keeping score at home, that's 28 weeks, 4,704 hours, and 282,240 minutes. What a lot of people don't realize, and sometimes it's a very difficult conversation you have to have with your client, is that you need to get comfortable with your new reality, and that your new reality is you're going to remain in custody, and if you're convicted, you're going to stay in prison for a long time. Miss Ghislaine Maxwell needs to hear that conversation, and very, very soon. You may recall Jacob Blake, as there were some issues up there in Kenosha, Wisconsin. Yeah, a little bit of rioting, a little bit of burning, because of the Jacob Blake situation when he was shot by a police officer. As you may also recall, back on August 23rd of 2020, Blake was at the home of Lakeisha Booker, the mother of 3 of his 6 children. They were celebrating their son's Israel's 8th birthday when an argument erupted between Booker and a neighbor. Mr. Blake says that he was saying, I'm going to take them out of here to get them out of here. Well, Booker called 911 as Blake was getting ready to leave with his 2 sons. The 911 dispatch states, Jacob Blake is here and he has the keys to a rental that I purchased and I need to take back, and he's not trying to release it. Needless to say, a dispatcher sent 3 officers from Kenosha Police Department to respond to the incident and alerted them that there's a warrant for Mr. Blake's arrest on charges of trespass, disorderly conduct, and 3rd-degree sexual assault, stemming from an alleged domestic violence incident earlier that summer. Prosecutors later dropped the sexual assault charge, and Blake pled guilty to 2 counts of disorderly conduct and was sentenced to 2 years on probation. Blake said that he was trying to put his children in the car when he said that he felt someone's arm on him and that he reacted. He said that he didn't realize that it was the police, and he was like, uh-oh, because when I did that, he slammed me up against the truck. Now, according to the investigative reports by the Kenosha County District Attorney's Office, the police officer involved in this incident, Rustin Shesky, recalled approaching Blake on the street and telling him, let's talk about this. Shesky said he then grabbed Blake's arm to arrest him and mentioned the warrant. Blake, however, claimed that the officer didn't say anything to him. A struggle ensued, and Shesky alleged that Blake reached for his waistline area, leading police to believe that he was reaching for a weapon. Shesky deployed his taser multiple times, but Blake pulled the prongs out of his skin. At that point, Blake says that he's rattled. He realizes that he did drop his knife, had a little pocket knife as he was referring to it as, and he picked it up and got off of him because they tased me and they fell on top of him. Blake says that he's always told the investigators that he had a knife at the time of the incident, but details given by his lawyer denied that there was ever a knife involved. Now, as you may recall, just last week, the district attorney decided they would not press charges, and the reason they did not do that was that they would have a difficult time overcoming self-defense by the officer because there was, in fact, a knife. Mr. Blake says the way that he reacted was that he wasn't thinking clearly at the time. Needless to say, he was shot numerous times. He's now paralyzed, and he is on probation. No civil suit has been filed yet, but I'm sure the Kenosha County and City are, in fact, probably trying to negotiate for some sort of settlement. Even though no criminal charges have been filed, the question is going to be whether the officer acted completely reasonable under the circumstances. The district attorney decided that they could not prove that case beyond a reasonable doubt. But remember, the burden of proof in a civil case is much lower, which is simply preponderance of evidence, more likely than not. So if the city believes that they are going to lose at trial, They're going to get their checkbooks out early. We'll see if they pay. Mr. Blake's attorney is the same attorney, Mr. Crump, that represented Breonna Taylor's family, where he received a $12 million settlement for the family against the city of Louisville, Kentucky. All right, Lori Vallow and Chad Daybell matters. You know, you can't go more than a couple of days without talking about this. But as you may recall, several weeks ago, the defense basically said, hey, here's some further discovery requests, and it came up during the hearing the other week regarding responses that had not been complied with. Well, Mr. Wood has responded and basically says, hey, in regards to the question of any statements that may be in existence that you intend to introduce at trial, let me know about all those. Well, Mr. Wood says, everything that we are going to use are contained in the police reports, the recordings of officers' body and or dash cameras, interview recordings, and defendants' jail phone calls and visits, all of which have either been previously provided or attached hereto. Nice try, defense, trying to get very specific because there's probably a lot of them. And they want to know, okay, you've given me probably hundreds of phone calls. I don't have time to go through and sit and listen to all of them. Can you tell me which ones they were? Which ones you intend to use? Yeah. If you hadn't maybe been so mean to the district attorney and maintained a good working relationship, he probably would have said, I intend to use jail call number 10, 20, 30. But no, now that you've been a complete jerk to him, accused him of being unethical and a liar, you've received everything. Go find it. Once again, statements that you intend to introduce as it relates to the co-defendant. Same response. Everything's been turned over. It's all on body cam videos, interviews, recordings, and jail calls. Go look for it. Defendants, as it relates to prior records, defendants' prior records have either been provided or are attached. Documents and tangible objects. Says, hey, defense counsel, I'm not going to tell you what I intend to use at trial just yet, but feel free to have your investigator coordinate with the Madison County Prosecutor's Office and law enforcement, and we'll let you go inspect anything in evidence. The defense can do that. You do that all the time in cases of great significance. The reports of examination and tests, states, witnesses, expert witnesses, basically see addendums. Unfortunately, the public records aren't releasing the addendums, so we're not able to find out exactly what the reports are. But we do know, and I think this is also of interest, a woman by the name of Rhonda Harper. She is being endorsed by the prosecution to testify consistent with her rebuttal report regarding the unreliability, the defense anonymous survey memo. Okay, we haven't seen the anonymous survey memo, but her report has already been provided to defense counsel, and her curriculum vitae is attached as well. As we've mentioned before, curriculum vitae is a fancy word for resume, but when you become an expert witness, your resume becomes a curriculum vitae. What we can glean from Ms. Harper's CV here is that she's been retained previously by law firms to provide consulting, research, and expert witness services in cases involving the Lanham Act, trademark, trade dress, patent, surveys, defamation, commercial reasonableness, licensing, retail merchandising, public relations, surveys, misleading advertising, likelihood of confusion. You get the drift. Criminal and civil. Why would she be testifying here? Well, I think what we can glean from this particular disclosure is that the defense has conducted a survey. Why would they conduct a survey? Well, when they filed their motion for a change of venue to move it out of Madison and or Rexburg there, you want to be able to say, we are not going to be able to conduct a fair trial. So you send people out into the city, into the town, you ask them, have you formed opinions as it relates to this particular case? And if they say yes or no, then you go from there. Now, normally you like to get the people that you've talked to about that, but they may not be completely truthful and accurate if they have to give their names. So my guess is that Ms. Harper is there to testify that the way the question was worded was somewhat prejudicial to the prosecution, as well as the flaws in these types of analysis. Normally, in change of venue cases, you don't change the venue early on. Sometimes it happens. I had a case not long ago where the judge says, you guys aren't going to get a fair trial here. I'm going to move it within my same jurisdiction, just the county over. We brought in hundreds and hundreds of jurors in that particular case. We were able to find people. But normally you wait until the jury selection process, and in that process called voir dire, then you see if you can seat 12 impartial jurors. So this is clearly being disclosed for the motion for change of venue, which should be taking place soon. As you may recall, the court said, since we were bogged down by all of these other motions that took a couple of days that we were previously going to discuss the change of venue, let's reschedule that. Nothing has been set as of yet. Gets a little more complicated when you have to start dealing with expert witnesses, other schedule, particularly are they available? Can they appear in person? Can they appear via Zoom? Gets a little more complicated. We'll obviously continue to follow that case because that's the case that a lot of our viewers and subscribers are interested in watching. That's all we have for you today. Have a wonderful day. We'll see you next week on Crime Talk.